A lasting power of attorney is a document that someone creates in their lifetime when they have capacity, which appoints attorneys, so people that they perhaps know and trust, or professional attorneys, to make decisions on their behalf if they are not able to make those decisions for themselves. There are two types of power of attorney. One is a power of attorney that deals with property and finance, and the other power of attorney will deal with health and welfare decisions. So the property and finance power of attorney can be used with the donor's consent. So the donor is the person that creates the power of attorney, and that can be used if the donor still has capacity but consents to the attorneys using the power of attorney for them. For example, if the donor was in hospital but had capacity and wasn't able to go to the bank to withdraw money or pay a utility bill, then they could ask their attorneys to do those tasks for them. It can also be used if the donor lacks capacity. So, for example, in later life, if they had dementia, or if there was an accident and someone was in a coma, they weren't able to make decisions for themselves, the property and finance power of attorney can then be used by the attorneys to make decisions for the donor. For example, if a house needed to be sold or if utility bills needed to be paid, then they would have access to the donor's finances to be able to keep things moving forward for them and make sure that they are looked after. When an attorney makes a decision under a power of attorney, it must always be a decision in the donor's best interest. So they can't benefit themselves or others, they must always benefit the donor. The other type of power of attorney is a health and welfare decisions power of attorney. Now, this power of attorney can only be used in the circumstances that the donor has lost capacity. So an attorney appointed under a health and welfare power of attorney can make decisions on the donor's behalf in terms of their medical treatment, and it's as if they are in the shoes of the donor and making those decisions on behalf of the donor. There's even a section in the lasting power of attorney for health and welfare which deals with life-sustaining treatment. So a donor can give authority to their attorneys to make decisions about life-sustaining treatment, and that includes either saying yes or no to life-sustaining treatment. There's another option that some people take, which is that they do not want their attorneys to be included and to be able to make decisions about life-sustaining treatment. There can be various reasons for this. It might be that they know their attorney and this would be too emotional for them. So there's different options that are available when setting up the power of attorney. When you meet with your solicitor, they will be well versed in giving advice to the donor about how best to set it up, the power of attorney, for your circumstances. They will take time to explain the power of attorney to you and will help you when choosing your attorneys to make sure that they are going to be appropriate people to be able to make these decisions for you, because it is a very big responsibility to be an attorney, and it has to be really someone that you know and trust, that can make sure that you're going to be looked after in later life. If somebody doesn't have a power of attorney in place and it's needed, the situation will be that they have their next of kin or somebody from the local authority will have to apply to the Court of Protection for a deputyship order to get the authority needed to be able to pay bills or even sell a property. Applications to the Court of Protection can take a very long time. I think at the moment the backlog is perhaps close to 12 months, and that can be very difficult. It can be that the house can't even be insured because there's nobody there that has authority to be able to insure the property. So it's very important that people prepare now for what might happen in later life. It might be that you never do need to rely on a power of attorney, and hopefully people will lead their lives without any need for it and always have capacity and always be able to look after themselves. But just in case it is required, it is very important to have those documents in place so that you can have peace of mind around the fact that you will be looked after. There is a section in both powers of attorney that deals with preferences and instructions. So preferences are things that you can include in the power of attorney that you would like to happen, and instructions are provisions in the power of attorney that must happen. So your attorneys must follow the preferences and instructions that you include in the document. For example, someone may decide that they don't want to have a blood transfusion for religious reasons, and if that's included in the power of attorney in the instructions section, an attorney must ensure that that person does not receive a blood transfusion in the future. It could be something as simple as, I really like banking with a particular bank, and you include a clause in the power of attorney that you must bank with that particular bank that's your favourite bank that you've always had throughout your whole lifetime. There are real life examples of when people have needed powers of attorney and haven't had them. The most famous example in recent years is around a presenter called Kate Garraway, who was unfortunately affected by COVID, in that her husband was in a coma and in hospital for a significant amount of time during the COVID pandemic, and she found that because her husband hadn't got powers of attorney in place, she couldn't even do anything as simple as pay the car insurance, and she's been very vocal about raising awareness around powers of attorney and how important it is for everybody to have a power of attorney in place.